Ladies and gentlemen, friends, welcome to the debate. Such a delight to see you all here tonight. Welcome. Friends, we are gathered here this evening to together explore international criminal justice and the International Criminal Court, to what extent it can help victims across the world. For you see, global justice isn't just a dream. It is not just a vision. Global justice is indeed a system that the International Criminal Court, the ICC, based in The Hague, wishes to enforce all across the world. The ICC wants justice for victims, for war crimes, crimes against humanity, and genocide. The ICC wants to put a global criminal justice system in place so that impunity may end all across the world, so that the perpetrators of horrendous crimes may not enjoy the freedom of impunity, that the awful crimes may come to an end, to be deterred, that people in regions of conflict may enjoy a sense of security, stability, and peace. However, my friends, whenever we talk or whenever we apply critical thinking upon an institution of justice, we must always ask ourselves, what can we do better? What can we do more? How do we help as many people as possible? And so that leads us to the ICC. For indeed, is the ICC capable of establishing the global criminal justice system? Can the ICC bring meaningful advancement of human rights on a global scale? Can the ICC bring justice to the guilty? Despite the conflicts ravaging across the lands and people of Syria, despite the military and political leaders walking away without international sanctions from the conflicts of Tibet, of Afghanistan, of Afghanistan and Iraq, despite minorities, ethnic minorities being persecuted, such as the Rohingya in Myanmar? Or must we be lenient in our judgment, considering that the court has merely existed for 15 years, and that the prior cases are very limited, that the foundations are not there for the ICC to build itself upon, that it's the first institution in its name? Well, my friends, this sounds like the makings of a debate, so let's indeed hear it. Our moderator for this evening is Lucinda David, my former coach and mentor. She's the PhD fellow at Circle here in Lund in economic geography. She's also an international debate educator. She has been speaking at the TEDx talks. She has founded Lund Debate Society, and she was the chief adjudicator of the World Universities Debating Championships. My friends, that was all from me. My work is done. Lucinda, the floor is yours.
Thank you. We'll have and see 3 rounds of debating. So the first round, each speaker will get uninterrupted 8 minutes of setting forth the arguments before you. Round 2, you will get a chance to ask the speakers. So all you have to do is raise your hand, try to keep it brief, and then ask your question. The opposing sides will also be allowed to question each other during this 20-minute round 2. The third round is when each speaker presents their closing remarks. And that will also be uninterrupted. And I think there will be a microphone going around if you'd like to ask a question as well. My advice is, while listening to the debate, is to let yourselves be persuaded by good arguments, write down some questions that you might have, and be brave and stand up later on. Because the speakers are here, and you can prod them accordingly. Alright, the motion for tonight is that this House believes that the International Criminal Court is an effective institution for enforcing a global criminal justice system. And our first speaker will be Leena Grover, who is the author of Interpreting Crimes in the Rome Statute of the International Criminal Court and was legal advisor to the chief negotiators on the aggression amendments in the Rome Statute.
Ladies and gentlemen, good evening and welcome. My name is Leena Grover. Tonight, my esteemed colleague Letizia Lo Giacco and I will explain why we believe the International Criminal Court is effective in enforcing a global criminal justice system. I will make 3 points. First, the court's enforcement is global. Second, it enforces international criminal justice. Third, the court enforces a system of enforcement. Ms. Lo Giacco will then explain the 3 ways we think the court's enforcement is effective. So let me begin with my first point, which is that the court is effective in enforcing international criminal justice with a global reach. The jurisdiction of the court, like any permanent international court, is determined by a treaty, and in turn, by the number of states that sign that treaty. When creating the court, states like Sweden thought very carefully about whether to create a court with universal jurisdiction, meaning any case could be brought before it, or whether to limit the court's jurisdiction. The former approach would have meant a powerful court with few states parties. The latter approach meant a slightly less powerful court with more states parties. Wisely, states chose the latter approach, drafting the Rome Statute, the treaty governing the court. Today, the Rome Statute has been signed by 124 states and entered into force just 4 years after its adoption, something that its drafters never expected. In real terms, this means that the court can exercise its jurisdiction over international crimes occurring on the territory of states parties or committed by their nationals. This includes sitting heads of state. Indeed, the court is the first in history to do this, having already charged 2 sitting heads of state. The court's jurisdiction can be triggered by the prosecutor, who receives thousands of letters from victims all over the world urging her to take action. As well, states can refer situations to the court, and have. And even if a state has not signed the Rome Statute, the UN Security Council can refer any situation in any country to the court. This is how, for example, the court acquired jurisdiction over the situation in Darfur, Sudan. Taken together, the court has established and enforces a body of international criminal law that has global reach. My second point is that the court enforces international criminal justice around the world. Let me explain. The Rome Statute and a document known as the Elements of Crimes, which was drafted after the Rome Statute and aids the court with its work, defines in detail more than 100 of the most serious offenses under international law. Acts that amount to genocide, other crimes against humanity, war crimes, and aggression. Prior to the Rome Statute and the Elements of Crimes, the definitions of these crimes were largely unwritten and subject to a lot of debate, which undermines the criminal justice principle of legality. Today, the definitions of crimes in the Rome Statute are relied on throughout the world in criminal legislation and proceedings, resulting in the enforcement of international criminal justice. As well, the Rome Statute and rules of procedure and evidence protect the rights of the accused to a fair trial so that criminal justice, not victor's justice, is enforced. In Nuremberg, evidence was collected at gunpoint. Even today, some post-conflict countries have weak judiciaries and weak fair trial protections. Therefore, although the court's trials are long, we can be sure that the rights of the accused are respected, which is essential to the enforcement of international criminal justice. My third point is that even though the court may be unable to exercise jurisdiction in some cases, the court has catalyzed the emergence of a system of actors who work to enforce its mandate. Take, for example, the conflict in Syria, which has cost the lives of so many and displaced many more. Syria has not ratified the Rome Statute, and the UN Security Council has been unable to refer the situation to the court. I ask you, does this mean that the citizens of Syria may never see individuals tried for international crimes committed against them? Certainly not. Seeing the inaction of the Security Council, the UN General Assembly stepped in to help. In December 2016, it established a mechanism, the first of its kind, to collect, analyze, and preserve evidence of the most serious crimes committed in Syria for use in a future trial that can take place once the war is over. And just last month, the UN Security Council adopted a similar resolution to collect and preserve evidence of crimes committed by ISIS against religious and ethnic minorities in Iraq. This evidence collection is essential for the enforcement of international criminal justice. Of course, there are also examples of national and hybrid tribunals taking up the task of dispensing justice. All of this demonstrates that since its establishment, the court has catalyzed the emergence of a system of actors, including states, to enforce the court's mandate. In conclusion, I have argued that the court's enforcement is global, delivers criminal justice, and has resulted in a system of enforcement involving many actors other than itself. I have also tried to show you that the court, like any pursuit of justice, is a deeply human endeavor and will therefore never be perfect. To quote a famous Canadian, Leonard Cohen, "There is a crack in everything. That's how the light gets in." In the same way, as a fellow Canadian, I would urge you not to measure the court's effectiveness against a standard of perfection, but instead to see its cracks and appreciate how far it has come despite them, to see how much light, how much justice has gotten in. Thank you.
All right, thank you very much. And now we'd like to invite the first speaker from the opposition, Ms. Iryna Marchuk. She's an associate professor at the Faculty of Law at the University of Copenhagen. She has worked as a visiting professor at the ICC and is the author of the fundamental concept of crime in international criminal law, a comparative law analysis.
Good evening, ladies and gentlemen. Thank you very much for inviting me to participate in the debate on this very important topic, marking the 15th anniversary of the International Criminal Court. My task today is relatively easy, as I have to argue that the ICC is ineffective in delivering credible international criminal justice. One does not have to be an expert in international criminal law or even a lawyer to arrive on this conclusion based on the very poor performance of the court during its 15 years. So let me give you some numbers. The court delivered 4 final judgments since it became operational in 2002. This is roughly 0.26 cases per year. Hardly an impressive record for the institution that requires colossal costs and resources. Imagine the Swedish Supreme Court delivering 4 judgments in 15 years. Even in the cases where convictions have been entered, the handling of the cases by the ICC prosecutor has been enormously criticized. Just to give you an example, in the first case against the Congolese warlord Thomas Lubanga, who was charged with the use of children in hostilities, the prosecutor failed to disclose the relevant information to the defense so it could adequately prepare for the defense of its client. This is a blatant violation of the right to a fair trial. At that stage, the judges of the ICC openly pronounced that the trial, quote, has been ruptured to such a degree that it's impossible to piece together the constitutive elements of a fair trial. Let me give you another example. Despite overwhelming evidence of sexual violence crimes committed by militia in DRC, the prosecutor only narrowly focused on the charges of child soldiers. Rape victims were appalled by the fact that their suffering went unnoticed. When collecting the evidence in war-torn areas, the ICC prosecutor often contracted local partners who acted as intermediaries. Some of them were not trustworthy and provided evidence of questionable quality. They only had interest to receive financial remuneration for their services, but had no interest to provide robust evidence that the prosecutor could use to build its case. The cost of the ICC maintenance is high. It runs up to $160 million per year, and already cost the international community over $1 billion since it became operational. Considering that many victims of the heinous crimes in the war-torn areas in Africa live on less than $1 per day, we should ask ourselves a question. Is the existence of the court justified at all? Isn't it a better idea to channel this money to the development projects such as building schools, hospitals, and infrastructure that would allow the affected communities to lead a normal life again? With the introduction of the reparations regime in the ICC, many victims were hoping that they will be to some extent compensated for their suffering at the end of the trials. In the first case, which I mentioned before, the ICC awarded collective reparations, despite the fact that child soldiers advocated for individual reparations that they could use to rebuild their shattered lives. Collective reparations is not what child soldiers asked for. In fact, the group of child soldiers is so diverse that they did not believe that they had sufficient connection to each other to benefit from collective reparations. In another case, the court awarded $250 as symbolic damages to 297 victims, a sum which was dismissed as meaningless by those who lost homes and loved ones in militia attacks in the DRC. The ICC has been plagued by the African bias claims, given the 9 out of 10 investigations carried out by the ICC prosecutor concerned the African states. Mistrust towards the court reached its peak in 2016 when 3 African ICC member states decided to depart the court. The African countries and the African Union have criticized the prosecutor's focus on the situations in Africa and using African warlords, dictators, and rebels as scapegoats for international criminal justice. The prosecutor did little to dispel the African bias myth, although she had every single opportunity to do so. In fact, there are currently 10 situations under preliminary examination in the docket of the ICC prosecutor where she has to decide whether to open a proper investigation to prosecute the crimes. These include some of the most serious and sensitive allegations, such as torture and ill treatment by Americans and CIA agents in Afghanistan, misconduct of UK forces in Iraq, crimes committed by Israel against Palestinians, crimes committed by the pro-Russian separatists in Ukraine. The situation in Afghanistan has been under preliminary examination for 12 years, with no decision of the ICC prosecutor in sight whether she will ever open an investigation in this situation. My point is that the ICC prosecutor has ignored very serious situations outside the African continent without offering any clues as to whether she will ever proceed to the fully fledged investigations. In these situations, it holds true that justice delayed is justice denied. My last point is moral integrity of the ICC prosecutor. The prosecutor must be a person of a high moral character. The recently leaked documents about the first ICC prosecutor, Luis Moreno Ocampo, reveal that while he was in office, he held offshore bank accounts and companies in tax havens in Caribbean, raising legitimate suspicions about his morality and the ICC integrity. Documents also reveal that after leaving his eminent position, the former prosecutor acted against the ICC objectives by advising those who are seen as potential targets of the ICC in Libya, acting in breach of the conflict of interest. He also discredited the work of the ICC by sharing confidential information with Hollywood celebrities and seeking advice, as ridiculous as it sounds, from Angelina Jolie whether to start an investigation in Palestine, making a Hollywood circus out of work of the court. To sum up, the ICC is ineffective due to its poor performance record, poor handling of cases, which resulted in many procedural irregularities, very high cost, which is not justified by its output, failure to meet the demands of the victims, the ICC prosecutors' inability to move beyond the African continent and move forward with other situations in the docket that have been under considerations for over a decade. Questionable integrity of those who occupy the highest positions in the ICC. Thank you very much for your attention.
Letizia is a doctoral candidate in international law at Lund University, where she also teaches. Her working experience includes extraordinary chambers in the courts of Cambodia, the Special Tribunal for Lebanon, and the ICC. The floor is yours.
Ladies and gentlemen, it is a pleasure to speak in front of this audience tonight and to argue in favor of such an important and timely motion. The ICC marks a revolution in international law. Being the first permanent international criminal court, it is entrusted with the mission to prosecute individuals for the most horrendous crimes and deliver justice to the victims. In explaining my position as to why all of you should be persuaded that the ICC is effective in enforcing a global criminal justice system, I wish to focus on three arguments. First, the ICC is effective in enforcing a criminal justice system because it works hand in hand with domestic criminal jurisdictions. Today, 124 states are party to the Rome Statute. Many states that have ratified the Rome Statute have implemented it at the national level. This signals an important achievement. States widely agreed with the terms of the Rome Statute to the extent that they have incorporated the statute into their own domestic criminal codes. In fact, based on the principle of complementarity, states and not the ICC are first mandated to prosecute the alleged perpetrators of international crimes under the material scope of the statute. This large involvement of domestic legal orders in building a uniform system of international criminal justice would have not been possible without the ratification of the Rome Statute and the establishment of the ICC. It is therefore a false myth to think of the ICC as a hegemonic institution where power rather than justice moves the action of the court. The ICC absolutely does not divest states of their power to prosecute. It just doesn't hold because of that. And this is a remarkable sign of effectiveness insofar as the system of international criminal justice can still perform regardless of the will of a single state. Second, the ICC is effective in enforcing a global criminal justice system because it's capable of delivering justice to victims. When discussing the international justice system, one should always bear in mind that this is not a discussion in the abstract, but it's a discussion that concerns real individuals that have been victimized. Victims are at the core of the mission of the Trust Fund for Victims, which has been established by the Rome Statute. This is a basin of financial resources to which governments, organizations, and private individuals as yourselves can contribute to support the victims of crimes directly. The Trust Fund provides assistance to victims, for instance in the form of rehabilitation programs for child soldiers, counseling for victims of gender-based crimes, job training and education. These programs have been operative since 2008 in Uganda and in the DRC, Democratic Republic of Congo. For example, children considered to be spies by warlords in Uganda have received reconstructive surgeries and artificial limbs to address their injuries. In the DRC, victims of gender-based violence are able to re-enter society after receiving physical rehabilitation and psychological support. Hence, the trust fund for victims allow victims to be reintegrated in their communities long before a judgment of conviction is delivered and an order of reparation is issued. Thirdly, the ICC enforces a system which operates according to impartiality, independence, and neutrality. These are the three core values of the court. With what I'm going to say now, I hope to wipe out some of the clichés that generally surround any discussion on the effectiveness of the ICC as an institution. Justice, as the term suggests, inherently means just. Justice is by definition fair and just. So the idea that the ICC is delivering justice makes appeal to the fact that even if cases are prosecuted by the ICC, this is the result of an unfair and unjust process, where the ICC prosecutor has shown bias in the exercise of their prosecutorial discretion. Hence, if cases selection is unjust, no real justice can be done. Well, I invite you to explore with me why this is to be deemed a cliché. There are currently 10 situations under investigation by the prosecution. These include Central African Republic, Uganda, Democratic Republic of Congo, Sudan, Kenya, Libya, Cote d'Ivoire, Mali, and Georgia. The situations in Central African Republic, Uganda, DRC, and Mali have been referred to the court by the governments of those states on their own volition. In other terms, these are all situations in which those states concerned have decided to trigger the jurisdiction of the ICC. Hence, it is incorrect to say that African countries have been targeted by the ICC, as it is also evident when observing some of the situations under preliminary examination, which include Ukraine, Palestine, Colombia, Iraq, and UK, and Afghanistan. In the eyes of any reasonable person, these situations necessitate investigation, having been the theater of thorny conflicts and massive human rights violations. So, to sum up, why domestic implementation of the statute? Actual justice for the victims and impartial, independence and neutral prosecution make the ICC effective in enforcing a global criminal justice system. Thank you very much.
All right, thank you for your comments. And now we'd like to welcome Tom Cornell to the floor. He recently worked as a visiting professional at the ICC, where he was judicial assistant to Judge Van Wijnget in the Appeals Division. He was mainly involved in the ongoing appeal in the case of Prosecutor versus Bemba.
Good evening, everyone. First of all, thank you very much to Lund University for hosting the event. I think it's a great idea. And my name is Tom Cornell. I appear as the second opposition speaker. Apologies for the slightly croaky voice. I'm afraid I've come down with a cold. But fear not, I won't take long because my case is a very straightforward one. I'm going to make two arguments as to why the ICC is not an effective institution for enforcing global criminal justice. My first argument is that the ICC lacks the support of a huge number of states, including several key global superpowers. Its jurisdiction cannot therefore be described as global in any real sense. Secondly, the ICC lacks effective mechanisms for making arrests and enforcing judgments. Thus, even where it does have jurisdiction, it is powerless to make that jurisdiction count. So turning to my first argument, which is the ICC's lack of universal political support. Now, this is clearly a huge issue when we consider the ICC as a global institution. Those in favour of the motion say that these are early days and that in any case the court can still be an effective tool even if not everyone has signed up to it. I'm afraid, ladies and gentlemen, that is wishful thinking. Here is a short list of states that have not signed the ICC statute. The US, Russia, China, India, Israel, North Korea, Syria, Rwanda, Vietnam, and many, many others. And in any event, and here I do agree with my learned friend Dr. Grover, that the real question is not who is and who is not a signatory to the ICC statute, but rather, is the ICC capable of ending impunity for those who are responsible for the worst atrocities on the planet? I say that clearly it is not, and unfortunately, it is difficult to see when and how that will change. So, to take an example and point that you will be familiar with, and it's already been discussed this evening, I want to look briefly at the situation in Syria. The civil war in Syria has been raging now since 2011. The Syrian Observatory for Human Rights estimates that as of July this year, between 300,000 and 500,000 individuals have been killed in that conflict. Around 100,000 of those are thought to have been civilian deaths. There is overwhelming evidence that President Bashar al-Assad has targeted the civilian population throughout that conflict, including by the use of chemical weapons. That, ladies and gentlemen, is a textbook definition of a crime against humanity. Unfortunately, as we know, Syria is not a signatory to the ICC statute, so the ICC does not have jurisdiction over those crimes. Even worse, however, is the fact that when the UN Security Council tried to refer the situation to the ICC in 2014, it was prevented from doing so by China and Russia. So what do we know? Russia is an open supporter of Assad, has sent troops to fight for him, and is a permanent member of the Security Council. Russia is not, lest we forget, a signatory to the ICC statute, and is clearly not inclined to do the ICC any favours. So the result of that is that one of the worst atrocities in living memory is likely to go uninvestigated, unprosecuted, and unpunished by the ICC, and that's despite the good intentions of the General Assembly setting up the committee to investigate. So regardless of the ICC's purported aims and objectives, an international criminal court that is incapable of prosecuting a crime of this magnitude cannot be considered effective. Put it this way, if the ICC had existed in the aftermath of the Second World War and had failed to bring charges against the Nazi regime for the crimes of the Holocaust, would we say that it was an effective institution for prosecuting the worst crimes known to humanity? I say that we would not. So turning briefly to my second argument, which is the ICC's lack of enforcement power. It is clear, unfortunately, that even where the ICC does have jurisdiction to investigate and prosecute crimes, it is often hindered by a lack of cooperation from ICC signatories. The ICC doesn't have its own police force, so it relies on the support of state parties to enforce its jurisdiction. However, even where a crime falls within its mandate, it is often prevented from seeing through that mandate by its very own signatories. So again, as a case in point, and we've already discussed this one as well, let's briefly recall the situation in Sudan and the manner in which President Bashir has to date avoided arrest. President Bashir is allegedly responsible for the persecution of hundreds of thousands of Darfuri civilians. He became the first sitting president to be indicted by the ICC on charges of genocide, crimes against humanity, and war crimes. 2 arrest warrants were issued on these charges in 2009 and then 2010. However, he has yet to be arrested, despite travelling extensively outside Sudan. A few months ago in July, whilst I was at the ICC issued an important decision against South Africa, one of the very first states to sign the ICC statute. And that decision basically said that South Africa had failed to cooperate with the arrest of President Bashir. The court confirmed what everyone already knew, which was that Bashir had travelled to South Africa in 2015 to attend a summit, and that the South African authorities had failed to comply with their obligation under the statute to arrest him. So what do you think happened to South Africa? Absolutely nothing. They weren't even referred to the Assembly of State Parties. And this is how the ICC decision was reported by the New York Times. Judges strongly criticised South Africa on Thursday for failing to arrest the president, Omar Hassan al-Bashir, when he visited Johannesburg for an African Union meeting in 2015. The judges strongly criticised South Africa for failing to arrest a wanted genocidaire. Ladies and gentlemen, if that's the best the ICC can do to enforce its jurisdiction in respect of atrocities, then it is simply not an effective criminal institution in any sense of the term. So, ladies and gentlemen, there you have it. Two simple points. One, the ICC is hamstrung by the failure of major states to sign up to its jurisdiction, and it's not just a handful of states. And secondly, even where the ICC does have jurisdiction, it is prevented from doing its work effectively because when the going gets tough, it can't force state parties to cooperate. We've seen that most obviously in relation to Sudan, but also in relation to the situations in Kenya, Georgia, and the Ukraine, among others. So, the result of these two separate points, I say, and I'm afraid to say it, is that the ICC cannot be considered an effective institution for enforcing a global criminal justice system. Thank you for listening.
All right, thank you very much. That concludes round one of this debate. We're now going to take a pre-vote and then we're going to take a final vote after round three. Luis, could you pull up Mentimeter? So if you have your phones, you can go to the website and you can vote on which side you think persuaded you. But the debate isn't over yet. We have 2 more rounds, and so the proposition has their work cut out for them. All right? Okay, now I'd like to open the second round. Speakers, do you have any questions for this side proposition?
I feel like asking a question.
Yes, please.
And this is to educate, I think, the audience a bit more on the cases that we have cited. And I'd like to pick on the last speaker's example on al-Bashir, and to say that this is a very special situation. It's a situation that has been so the situation in Sudan has been referred by the UN Security Council, and the prosecutor has decided to indict a person that is the sitting head of state of Sudan. I say that this is a special case, not only because it's a situation that has been referred by the UN Security Council to the court, but also because it involves the application of a rule that has been critical in a way. This is Rule 98 of the statute that deals with immunity. So I think that's a special case that makes me think that if you want to judge on the basis of the effectiveness of the ICC on the basis of the al-Bashir case, maybe you should prefer to have a larger view on the cases and think of Kenyatta, the sitting head of state of Kenya, that in fact appeared before the court regardless of his immunities. So just for clarity, this Rule 98 says that the court cannot request states to demand states to act in contravention to the laws on immunity, and this may be one of such cases. So I wouldn't rely on the al-Bashir case to make the argument on the ineffectiveness of the ICC.
So you're suggesting that one of the examples that Tom brought forward, it was in a way an unfair expectation of the ICC to demand this level of enforcement, given that it wasn't the right place for the ICC.
I'm just saying that it's a very critical issue where immunities so procedural immunity for sitting heads of state can be invoked, and you have an order of cooperation to state parties.
Okay. Would you like to respond, Tom?
Yeah, I'll try. I think I agree up to a point. I mean, that's really what South Africa said in the hearing. They said, look at Rule 98, state immunities, or immunity of sitting head of state. But the ICC said, well, that's not good enough. So it found against South Africa. I think my point is that despite the fact the court found that South Africa was in breach of its obligations under the statute, there was really nothing that could come of it. And that's just the nature of the ICC statute and how it works. And I think it was an important judgment because it sort of laid down the law and said, if you don't cooperate, we're going to wag our finger at you. But I think my point is that in the context of a genocide of this seriousness, this sort of legal wrangling, 6-7 years after an arrest warrant was issued, 2 years after the breach of obligation by South Africa, I think it's just not good enough. And given the sort of South Africa's general sort of reluctance to cooperate, I think the whole situation can be at least viewed as a sort of black mark against the ICC's effectiveness, certainly.
If I can just add as
Yes,
well,
of
few words. I would like to say that South Africa is not the only offender. So President al-Bashir, he traveled to other countries, he went to Chad and Malawi, and every single time he was able to travel in and out of the country. So this is not the first time that we have proceedings against the state that has ratified the Rome Statute and is not complying with its obligation under the Rome Statute. So here the point is that the states that ratified the statute, they don't want even to commit to their obligations. And as well, another problem is that the situation was referred by the United Nations Security Council, but the United Nations Security Council does absolutely nothing to facilitate the arrest of al-Bashir. So the only thing they did was to refer the case to the ICC prosecutor. The prosecutor's hands are tied. The president is traveling from one African to another, participating in various conferences on official visits. The UN Security Council sits in New York and says, well, it's too bad that he was not arrested. So I think that this case is actually, as a signature case, is a really, really good example why the ICC is not effective, as it does not enjoy the broad cooperation, not only from South Africa, but beyond that. Another reference that was made by Ms. Lo Giacco was the reference to Kenyatta case. Kenyatta is the sitting president of Kenya, and in fact he voluntarily appeared before the International Criminal Court. Whereas he voluntarily appeared before the court, there was smear campaign against the victims that tried to testify against him. So at the end, the fact that he showed up before the court gave him some popular votes because none of the victims came before the court to testify against him. So in the middle of the case, the prosecutor had to acknowledge the defeat, saying that there was not enough evidence to proceed with the case. So Kenyatta went back home to Kenya in 2017. If you follow the news, there was another round of elections. Kenyatta was re-elected as a president. So here we talk about the effectiveness, about the irrelevance of immunities, but we can see that al-Bashir is still sitting president of Sudan. None of the states wanted to do anything to arrest him. In the case of Kenyatta, he went to the ICC, he became a national hero, he came back, enjoying even more popular support in Kenya, and he was elected as a president again. So I think that our argument about the ineffectiveness of the court is a pretty good one.
Okay, would you guys like to respond?
Yeah, I mean, I want to have this debate with all of you on the planet Earth. And on the planet Earth, we have international law, which is decided by states. And so to point to the court and say, you can't enforce your judgments, you have to ask yourself, well, what were states willing to agree to? And they were not willing to agree to tie their hands to that extent, to give the court a police force, for example, that could go into countries and arrest people. They were not willing to relinquish their sovereignty to that extent. But what they did do was constrain their sovereignty more than has ever been accomplished in the history of international law. And they're doing so even further as of this December. So the crime of aggression was part of the Rome Statute, but not defined. And the states of the world came together and defined the crime, and in December, they're going to tie their hands once again by agreeing to activate the court's jurisdiction over the crime of aggression, which is considered the supreme crime, which encompasses the evil of all the crimes that follow it. So, you know, chipping away at state sovereignty to get at these crimes is a gradual process, and we've come farther than we've ever been before. And if you're talking about, you know, the political dimension of these cases and, you know, a lack of cooperation by South Africa, people not being arrested, it's not that states didn't see this potentially happening. That's why they established the Assembly of States Parties, which is the legislative body for the court, and that's where the diplomatic work takes place. That's where states quietly meet with each other, gently prod each other, remind them of their commitments, and try to get them to do what they signed up to do. And sometimes you get results by going that way and not, you know, you can have a judgment from a court saying, condemning South Africa, but parallel to that, you have the Assembly of States Parties talking to African states, listening to their concerns about bias, and trying to find a middle road. And that Assembly of States Parties can can adopt a resolution and guide the work of the court. So it's not that the court is naive to the political dimension of its work. It's designed to have a legislative body that deals with those issues. But to bring it back to the court and say, well, you don't enforce your judgments and you don't see the political dimension of your work, is really to let states off the hook and not recognize that states created this court, and only states can create any court. So if you're going to point to the court and say, look at what's wrong with it, show me the other court that states are willing to create, that are the other court that will enforce justice better than this court. And if you can't show me that court, then I think there is an argument in favor of the court's effectiveness.
Are there any questions from the audience? It can be on this topic, or it can be on another argument that you just heard, or just a question. Yes, please. Can you give that gentleman the microphone? Thank you.
Hi. So my question relates to one of the things the against I mentioned before, that the International Criminal Court should potentially be abolished. So my question is there any evidence that such an abolishment would lead to a better system, or would we just be back on square zero?
Would you like to respond?
Yeah, well, we didn't exactly say that the court should be abolished, right? We are questioning the effectiveness of the ICC, but we didn't say that it could be abolished. Of course, there are other ways in which the international criminal justice could be enforced. And we have seen, for example, that hope tribunals that were established in the aftermath of the conflicts in the former Yugoslavia and Rwanda. As well, there were hybrid tribunals, and hybrid tribunals are actually very effective tools in prosecuting international crimes. Let me give you an example of Sierra Leone. The conflict ravaged there for about 10 years. There was a Truth and Reconciliation Commission that was established to deal with aftermath of the conflict. That wasn't enough. Then the Sierra Leonean government asked the United Nations to help to establish the court that will prosecute the serious crimes, and was the court to be based in Freetown. The court was based in Freetown. It prosecuted all the parties of the conflict, all the rebel groups. And at the end, the court also got Charles Taylor into custody, who was the former president of Liberia, who supplied arms and weapons to the rebels in Sierra Leone for the exchange of blood diamonds. This is a really successful example of the prosecution, where you have the combined domestic, national, and international efforts. Victims felt that they were heard because the court was based in Freetown. Many of them actually came up and watched proceedings during the public galleries. I was working at the special court for Sierra Leone, and when the judgment again, and when some of the judgments were delivered in Freetown, some of the victims were sitting and crying in the public gallery. So it really had this smoothing effect, one can say, on the victims who felt that they were part of the process. Whereas the problem with the ICC that it's really far away from the conflicts, and the victims, they do not feel that they are being represented. Let's say in the DRC case, Thomas Lubanga was charged with the use of child soldiers. When this news was learned by the victims in the DRC, they didn't even know it was a crime under international law. They were more appalled that crimes such as killings and rape and sexual violence were not prosecuted. So I do think that maybe hybrid mechanisms of justice in combination with other forms of restorative justice, transitional justice, could be a better tool to address the conflicts in different parts of the world. And they would also be able to offer solutions that tailor much more to the individual circumstances of the conflict. Thank you.
Yes?
I have no issue with what was just said, and I don't think the court precludes any of that from happening. And that's the mistake that some people think, is that the court, by virtue of existing, the court is the only option. But it isn't. It never said it was. So the court can exist alongside other transitional justice mechanisms. The court is there if national prosecutions don't take place, if there's no hybrid tribunal. It's not the place of first resort. It can be the place of last resort. There's nothing in its statute that excludes any of this from happening.
In theory, though, right? Because there is a lot of political capital and genuine resources put to having the International Criminal Court. And one could argue it might crowd out the other sort of tribunals that people could use that are more tailored to the context of these countries.
I don't think there's a funding issue. I don't think that maybe there's an issue with rhetoric. You know, the rhetoric might be larger than it needs to be, but the rhetoric of the court can be toned down, and I think it is being toned down. I think in the first 15 years what the court has learned is not to overpromise and to really be a little bit more modest about what it's holding itself out to do. So it is not the place to go for peace and security. That's the mandate of the Security Council. It is not the place to end impunity all over the world. It's one piece of a much larger puzzle. And I think there's a certain modesty that you see emerging in this next decade of the court's work, and rightly so, because it should create enough room for all of these other possibilities.
Okay. Yes, any more questions? Yes, Sophia?
I hope I'm not repetitive, but I think one of the standards, at least of the opposition, to measure the effectiveness of the court is the situation of the victims during or after the proceedings. So my question is more addressed to the proposition. Do you think that, do you have any response to the opposition's suggestion that the high cost of maintaining such permanent institution could be allocated more efficiently towards kind of like towards reparation to the victims directly, rather than trying to institutionalize justice in places where it's like the standards of justice are not that high?
Thank you.
I think these are two different projects that are tied together, and in my second point I try to make explicit the fact that the court is promoting programs in favor of the victims long before a judgment is issued. And this is in support of victims of crimes that are called beneficiaries, so are not victims in a judicial sense, like victims so qualified by the court for the purposes of a reparation award once the conviction of an individual is issued. But these are a series of programs in favor of children that have been mutilated, or people that have been subjected to gender-based violence through counseling activities. So there is a range of programs that have already been sustained by the court in certain situations. So a larger group of individuals can benefit from these programs, and not just the victims in a judicial sense. And then alongside this, you have, of course, victims that can receive a symbolic compensation or collective reparations. And I think my esteemed opponents made the point that collective reparation was not something that was asked for child soldiers. I think the purpose is not to allocate as much money as possible to single individuals, but to deliver justice to the community itself.
I just wanted to add that I agree that it's not a mutually exclusive thing, and what we're seeing at the international level is that the largest donors to transitional justice, the European Union and the United Nations, are really learning from the last 20 years of transitional justice efforts. And so now they've both included the importance of national consultations when designing transitional justice mechanisms. And what that means is they're talking to the victims and asking the victims, what do you want? And they're not assuming that criminal justice is the only path forward. They're asking the victims, do you want a trial? If you want a trial, is there something else that you want? Symbolic reparations, individual reparations, a Truth and Reconciliation Commission, education reform. What do you want? Constitutional reforms, an ombudsman to control corruption. So the approach to transitional justice has completely changed, I would say, in the last 5 to 10 years. And it shows that increasingly the court is not considered the first and last step for giving justice to victims.
Give the opposition a chance to respond.
Well, just maybe to rehearse what we already said about the victims. The victims feel fooled, they feel disillusioned by the promises that were made to them. In the very beginning, they thought it was a great potential that they could actually get some reparations from the ICC. They can use this little money to rebuild their lives. Just imagine you have a child soldier who was 7 or 8 years old, was drugged by the rebels, was forced to commit some of the most awful crimes, missed 10 years of his life, has no education. Can you ask this child soldier, do you want a constitutional reform? Do you want the court to deliver justice? What these victims need, they just need normal life. They need to go back to school, they need to get some education, they need to get some jobs, they need to get reintegrated. And when the victims were asked what they wanted individual reparations, something for themselves, something that they can use to rebuild their life. As well, I remember I had this harrowing conversation with one of the victims who testified on one of the trials, who was an amputee. And she said, you know what, I think that the person who is in the docket has a much better life than I have, because the person, at least this person who is accused of international crimes, gets, his breakfast, dinner and lunch. I have to beg on the streets to get this money. And she said, other politicians do not care about us. She said, what white men in Europe care more about us. So, this is just to show you the point that these victims, when they become part of the proceedings, they have very, very basic needs that they have to be fulfilled. They don't think about international justice, international criminal court, constitutional reform, fighting corruption. What they need is just some monetary compensation that will help them to move on with their lives. And at the end of the trial in the Borgen case, the first order that the court issued was the order of symbolic reparations, art installations about the conflict in the DRC. As a former child soldier, a former rape victim, would you want to go and see how these crimes are being commemorated during an art exhibition? I don't think this is what you want. What you want to move on with your life, and you want to get some means to embark upon another stage of your life, hopefully as a more educated person and having more opportunities in life.
Actually, it's not just 3 meals. I read that people waiting for their trial in The Hague, they get access to Nintendo Wii, so they can have some entertainment, like Milosevic, for example. So it's a bit strange.
Yeah, exactly. And for example, when I was working on the trial of Charles Taylor, he wanted to get only African food. He was unhappy with the food that he was served in the prison. He wanted to see more of his wife. So in fact, he fathered a kid when he was in the prison. And then you think about all these poor victims who live on less than $1 per day, this poor woman begging on the streets, and she is not able even to cover some of her basic expenses. So that's some of the victims who came to testify to The Hague, they didn't even have clothes. So, when we look at the situation, what exactly victims need, and then we compare it to this lofty words about international criminal justice, it's a completely 2 different realities that we are discussing.
You want to add something to it?
I have nothing to add.
Okay.
I would just say, I don't know that that's a structural problem. I think it's just, I mean, we should all just donate more to the Victims' Trust Fund. That's not on the court necessarily. It's on the states and individuals and whether we bother to donate that money or not. It has to come from somewhere. So.
Yeah. We have time for one more question from the audience. Yes? I guess
I can just do it without the microphone. I was just wondering, since, I mean, it is a relatively young institution, 15 years isn't a long time for something so groundbreaking. I guess, I mean, does the opposition think that there's possibility for improvement and, you know, like a long-term solution to what you feel is the ineffectiveness of it?
Okay.
It's difficult to answer without stepping outside the parameters of the debate, and this is something I'm going to go back to in my closing speech, but what we're talking about is the present sort of situation, and it's an entirely separate question as to whether or not the court has sort of room to improve, or whether or not in the next decade or 2 decades it can actually become something approaching an effective criminal justice system. But I think even if you sort of look to the future, it's difficult to see how the bits and pieces will come together to create that criminal justice system. I think just looking at the issues that I raised about jurisdiction and lack of cooperation, it seems to me that given sort of recent events in Africa, for example, with this sort of talk of mass withdrawal, that hasn't happened, fortunately. But I think the direction of travel at the moment is away from the court becoming a stronger institution as opposed to towards that. So I think these are very delicate, critical times in the ICC, and I'd like to think I'm wrong, but I'm not sure.
I'll just add a few words. I mentioned this very difficult situation in Afghanistan and the situation in Palestine, in Ukraine, and the situation in Iraq. So technically you would think that if the ICC prosecutor was very bold in her strategy and she would pick up and she would go against these big states, because although neither Russia nor US ratified the Rome Statute, the crimes were committed on the territory of states that have ratified the statute. So technically the ICC prosecutor could go after Americans, could go after Russians. And that could be the strategy of the ICC prosecutor, but it can potentially do more harm than good. Because can you imagine that the ICC prosecutor is starting the case in Ukraine and then issues state arrest warrants against Russians? Russians already are not cooperating, they're part of the United Nations Security Council. At the same time, the ICC prosecutor decides to initiate this investigation into the situation in Afghanistan, then Americans are getting pissed as well. Americans and Russians will become very powerful allies, and here, potentially, the ICC prosecutor can eliminate half of the permanent members of the United Nations Security Council, so that would undermine the legitimacy of the International Criminal Court even more. So it's very, very difficult to say what exactly the strategy of the ICC prosecutor should be, because on the one hand, the ICC prosecutor should show to the world that she should be able to prosecute the crimes globally, but if she moves forward with these very sensitive situations, that might create another much more powerful wave of backlash against the ICC that the court will not be able to survive as an institution.
I think it's very easy to judge and evaluate the court by looking at sort of the number of decisions that they've made. But I do want to say that at least personally, I think it's a triumph of society and our community that we have now gone this far to establish the system of universal crimes against humanity. And I would only like to talk about the Philippines, for example. If you've heard about the crazy president the Philippines has now, Duterte, he's basically killed now 10,000 Filipinos for suspected drug use. No trial, police just go out to their homes and shoot them. And we recently filed a case in the ICC against the sitting president. Now, we're under no illusion that anything will happen, but the fact that we can go to an outside court to legitimize the complaints against what the most powerful are doing within the Philippines is already for us a huge triumph for our community. And I think that's what we have to consider. Yes, we can look at the results, but we can also look at more complex processes that the ICC has enabled now for many people around the world who are on the fringes and have no recourse because the powerful are oppressing them. Yeah. Okay, we're going now to round 3. And we're going to welcome the speakers to give their closing remarks.
Just a few things though. I'd like to clarify in light of the discussions just now that the motion relates to whether or not the ICC is currently an effective institution for enforcing a global criminal justice system. So I think it's a separate argument altogether to talk about the future and whether or not what we have at the moment might amount to a step in the right direction, or whether it might provide hope to people that impunity could at some stage in the future be ended. But I think concentrating on the here and now, I would confirm what I said in my first statement, which is that it's not currently an effective institution. So having clarified that, I just want to run through a couple of things very quickly. A point was raised in one of the first speeches regarding the sitting heads of state, and of course it is impressive that the ICC has been able to charge sitting heads of state, but of course we know that in both cases in which sitting heads of state were charged, nothing came of those charges. I've spoken about Bashir, but of course the same is true of President Kenyatta in Kenya. So again, we have this problem of even where the court has jurisdiction, either via Security Council referral or because the state itself refers the situation, it's often the case that nothing gets done because of a lack of cooperation, either by the state that's being investigated or by another state. So I'll leave that there. A sort of final point, I think. We spoke very briefly in that discussion about constraining sovereignty and that sort of moving towards the argument that really this isn't the ICC's fault and the ICC is constrained by the limitations of international law and the limitations of the statute. And of course, that's absolutely true. But I think it's important that we view this argument not from the point of view of international lawyers, but just generally, and consider whether, despite those limitations, notwithstanding those limitations, which are absolutely there, the ICC is an effective institution. Because it's simply not good enough to say, oh, well, you know, it's not the ICC's fault. The ICC clearly has good intentions, and if all these things don't come together, then we can't blame the ICC for everything. I agree with that. But unfortunately, when we look at the question, which is at the centre of this debate, is the ICC an effective institution? It doesn't matter whose fault it is. The simple truth is, at the end of the day, that the ICC is not currently an effective institution. And Dr. Grover finished her opening speech with a quote from Leonard Cohen. Let me counter with a bit of T.S. Eliot, who once said that the road to hell is paved with good intentions. Thank you very much, ladies and gentlemen.
Thanks so much, Tom, and we'll now welcome Letizia back to the floor.
There is always something wrong with my mic. Ladies and gentlemen, we have listened to the arguments as to why we shouldn't consider the ICC an effective institution in building a system of international justice system globally. I think the arguments that we heard are arguments of realpolitik, are arguments that refer back to a structure of power that is present in international relations, unfortunately. The purpose of this debate is not to evaluate effectiveness against this balance of power, but rather to take this into account and to evaluate how far the ICC has gone in only 15 years. So I would say, if you think of the court as the first permanent court in history that was established in 1998, with only 2 experiments prior to it, I think it's an amazing result what we have. The mere fact that there is such a court in existence is such a revolution. So I would invite you to think of the court and evaluate its effectiveness not as an actor in itself, but as an actor inserted in a context of domestic jurisdictions and other actors in transitional justice that work alongside the court. So, being such a revolutionary project, I think that we need to apply some grain of cynicism when evaluating the effectiveness, but we need to apply more than a grain of commitment to improve it. Thanks.
Thank you very much. And now I'd like to welcome Iryna.
So I don't have much to say. I would like to say that I hope that Tom and I have established beyond reasonable doubt that the ICC is ineffective in delivering credible international criminal justice. Just few final points. The point that was brought by Ms. Lo Giacco was about realpolitik, and I would like to say that although the ICC is not a political institution, but decisions of the court do have political impact. Here, international law and international relations are intertwined. You cannot separate the two. Law and politics go hand in hand. The decisions which are made by the judges and by the ICC prosecutor, they do have a political impact. So looking at the court as an abstract institution without considering any political implications of its work will not give us a full picture of how the International Criminal Court operates. The first speaker, Dr. Grover, she was talking about the contribution of the court to the advancement of the substantive part of international criminal law. We have all the wonderful definitions of crimes, but I would like to say that the fact that we have all these wonderful definitions of crimes, this is exactly doesn't help with the victims. So what we have to think about the local impact of the International Criminal Court. And I'm very happy that right now we actually have a research being carried out measuring the local impact of the institution. Researchers, lawyers, being educated at the Faculty of Laws are trying to adopt some empirical methods. They're going to the affected local communities, trying to collect the research and see what exactly international communities want, what exactly affected communities want, and what the International Criminal Court can deliver. As well, there was a point mentioned by the proposition about the positive complementarity and the catalyzing impact that the International Criminal Court does have on national jurisdictions. I would like to say that there is very limited evidence that the International Criminal Court has in fact produced any catalyzing impact on the ability of national jurisdictions to prosecute international crimes. Surely, if the crimes were committed in the developed countries like in Sweden or Denmark, these countries would be able to prosecute these crimes because you have a sound judicial system. But when you look at the states that are broken and are beyond repair, it's highly questionable, even if the states have ratified the Rome Statute, that they will have the abilities to prosecute these crimes. So I have many more arguments to say, and I hope if you have the reception afterwards, I can add a few other words of wisdom criticizing the International Criminal Court. Thank you very much.
All right, thanks very much. And last but not the least,
I want to comment briefly on the prosecutor of the court. Whatever shortcomings there were in terms of his performance, he's gone, and there's another prosecutor. And the court has started to invite NGOs to participate in the appointment of judges and in the appointment of the prosecutor to receive critical feedback on their qualifications. So this is an organization, an institution that's very much learning from past experience. In terms of the Victims' Trust Fund, I think we should also bear in mind that the court has the power to issue seizure and forfeiture orders against the accused. So some of these people that are appearing before the court have actually amassed large fortunes on the backs of their victims, and those funds can be seized and used to make reparations to the victims. In terms of the lack of state support for the court, I think that's on us as citizens, and it's up to us to let our politicians know that we do care about a conflict in Syria, we do care about Bashir being arrested. The media makes us aware of the work of the court, and in turn it's our responsibility to let our politicians know that we want them to uphold their commitments that they made under the Rome Statute. In terms of Bashir not being arrested, he hasn't been arrested, but he's also not traveling the world free of worries. So, like for him and for Pinochet, the world map has shrunk because there are far more countries that would not welcome him than would. So it hasn't resulted in his arrest, the work of the court, but it certainly has made his life significantly more difficult. And it's hard to prove a negative, but I would like to think that there are other world leaders who would think twice, seeing what's happened to him, before they head down a similar course of action. And finally, I'd like to say something about what's known as a justice cascade. So I've talked a lot about where we've come from and where we are today, but I also want to point out what's happened since the court came into force. So the court doesn't impose a duty on states to prosecute citizens who've committed crimes against humanity, for example. The states couldn't agree on creating that kind of duty because they had much too much sympathy for the work of the South Africans creating a Truth and Reconciliation Commission. So there's no duty on states to prosecute. But since the creation of the court, the UN International Law Commission has mobilized support to draft a convention on crimes against humanity, which is similar to the Genocide Convention, and states ratifying it would have an obligation to prosecute anyone who commits crimes against humanity on its territory. So that's a justice cascade. And the other thing I would say is it's not fair to say that nothing has happened since the court has been established in terms of domestic prosecutions. You had the Iraqi case where you had Saddam Hussein prosecuted, you have the Cambodia proceedings, and you have the East Timor proceedings, and you have Sierra Leone as well. There are many other examples, and there's a lot of potential for national prosecutions to unfold because we have this national legislation that mirrors what's in the Rome Statute. Thanks.
Please thank all the speakers again for the wonderful speeches, and now you will get a chance to make your final vote. I urge you to let the arguments update your point of view, and if you want to change your mind, do so. Okay, don't think about it too long. The voting was faster in the pre-vote.
So you press show it winner, then the results will be.
Well, there's people are still voting. I think last time we had around 60, so it's good that people are considering new points. People say sometimes after a debate, they end up sitting on the fence, being undecided rather than undecided, so. All right, we've reached 59? 60, okay, Louise, please. Is that? Show the winner. Is it a tie? Yeah. Are you sure? Yeah. Show the winner. Have you pressed show the winner? Yeah. Okay. Wonderful. Another round of applause. Managed to persuade some of the people that indeed the ICC is an effective enforcer of international criminal justice, as well as that it isn't. So it's even Steven, basically. So, yeah, well, Tom would like to see the statistics. We'll send it to you. Okay, I hand the floor back
Yes, hello again. One more chance for the spotlight from me as well. I hope you all enjoyed this. This was merely the first step, as I told you, debaters, of the revolution of Swedish debating culture. So I hope you all enjoyed it. Please keep your eyes open for the next step as well. And, you know, one more round of applause for the debaters. Thank you so much.
In the name of the debaters, and this is a big thank to the organizers of this event. A special thank to Lucinda and to Primus that have been so keen on following us in every step in the organization of this event, and then of course to the Association of Students. Thank you very much.
We got some flowers for you.
Oh, thanks.
And I see Lucinda made some time for all of you to get some selfies, some autographs, and maybe some of you have questions you want to ask in person to all of these people. So, yeah, go ahead. Thank you so much for coming again.